my colleague Ms. Powell about the organization, so I won't reiterate any of that. I will say that historically you have heard that Fair Girls clients have all too often been treated as criminals when local and federal legislation says that we're supposed to be treating them as victims of crime. And over the last 15 years, through concerted efforts of raising awareness and specialized human trafficking training, we have made big progress in the law enforcement community. And just in the interest of full disclosure, in my past life, I was a prosecutor at the U.S. Attorney's Office. I prosecuted human trafficking, child abuse, and sex abuse cases, just like the ones we're talking about here. Through educating law enforcement partners, judges, and the courts, we've begun to realize that the old model of prosecution and how we prosecuted these cases was not only ineffective and unproductive, but fundamentally misunderstood the coercion at play in a trafficking situation. Trying to treat victims like criminal defendants in order to leverage them to cooperate against their trafficker has never worked, and it would not continue to work, and experienced prosecutors are starting to see that. And so that trend of prosecution is changing. Experienced prosecutors know that if you treat victims like victims and stop the perpetuating treating them as criminals, then they will get the resources that they need to stabilize their lives and lower recidivism. If we move towards trauma-informed, victim-centered prosecution, hopefully one day we don't need a bill like this. That would be our hope. But right now, given the history of how these prosecutions have been done over time, not only in the district but across the country, and the fact that we sometimes get it wrong for the myriad of reasons of misidentification, we still need this bill. It is an important and necessary safety net for victims of trafficking in the district. Most of these victims, as you heard Ms. Amaya say, just want to rebuild their lives. They just want to restart. They want to be productive members of society, but the barriers of these wrongful convictions are standing in their way. This bill allows for this safety net, while still, as my colleague here says, providing a rigorous and adversarial process, which is a process that was hammered out on the federal level when we talked to prosecutors and got lots of stakeholders involved, figuring out ways that we could make it so that people are very comfortable that this bill could not be abused. So I think that this bill, which, in drafting it, we modeled on the federal bill, it is a balanced and common sense approach as well. I want to speak to the expansiveness of the bill because you asked a question specifically to that. It was drafted with the intent to be expansive, and that is to reflect the reality of the victims. And all of our policy at Fair Girls is survivor-informed, victim-centered. It's based and rooted in the experiences of the clients that you heard Andrea talk about, and that is true especially with this bill. One of the problems that we have heard from clients is that sealing and vacature bills in other statutes in other states are not sufficient and therefore not effective in helping them move on with their lives because they don't encompass all the types of crimes that we're seeing traffickers force victims to do. I personally have seen traffickers force victims to take drugs, sell drugs, give drugs to minor victims that they're working beside. I've seen them have to steal from the people that they were sold to. I've seen them have to drive under the influence and without a license because their identification was taken by their trafficker. These are all things I've seen just in cases that I handled. I've seen traffickers stash firearms underneath the victim to ensure that it was he didn't have direct criminal exposure for that firearm, and also to use it as a coercive tool against the victim. All these things, I give these examples to show that one of the things that we've had struggled with is making a law that balances not only wanting to treat victims as victims from the beginning and return them to the status in which they should be prior to being victimized, but also to balance the concern that people are that this statute will be abused by people that are not truly victims. To make vacature legislation actually helpful for victims and to make it survivor-informed, it must be expansive enough to reflect the reality of modern-day slavery, the reality that I just described to you. There's national recognition, as we've kind of touched upon in testimony, that this is true and this is necessary across the country. The Trafficking Survivors Relief Amendment Act is exactly the kind of legislation that was envisioned by Congress when they passed the Justice for Victims of Trafficking Act in 2015, and where they set up grant incentives incentivizing for applicants from states that had bills just like the one before you today on the books, including all those components. That's in Title 10 of JVTA. In addition, as we've already touched upon, the federal bill that's before the House and the Senate currently and is bipartisan support and is gaining support every day, has the sign-on of many national organizations. So I appreciate what Chairman Allen has said about that this isn't a matter of if we do it in the district, but when we do it and how we do it. And I appreciate that. And I guess I'm here to tell you that getting mired down in the discrepancy between violent and nonviolent is not particularly helpful in this context. And if you have more specific questions about that, I'm happy to address that specifically. But I want to be respectful of the fact that I'm almost out of time.
Thank you very much, and I will come back to ask you some of those questions. Thank you very much.